Buckley versus Valeo, the 1976 decision that built America's dark money architecture. Original publication date, December 3, 2025 by Carrie Clendenning and read by an automated voice. The Supreme Court's 1976 per curiam opinion in Buckley versus Valeo established the constitutional framework that makes dark money and unlimited campaign spending legally possible, not Citizens United. While Citizens United, 2010, became the public lightning rod for criticism, legal scholars increasingly recognize it as merely an extension of doctrines Buckley cemented 34 years earlier. As Columbia law professor Richard Briffault argues, Buckley produced a campaign finance law that Congress never enacted, and set the stage for many of the pathologies that have marked the campaign finance system ever since. The case struck down post-Watergate spending limits while creating three foundational doctrines. Money spent on politics equals protected speech. Independent expenditures cannot be limited because they don't corrupt. And contributions and expenditures deserve different constitutional treatment. These holdings constructed the legal architecture that dark money now flows through. The Watergate scandal drove comprehensive reform that the court dismantled when Nixon resigned on August 9, 1974. The Watergate investigations had exposed campaign finance as central to political corruption. 22 individuals and 17 corporations pleaded guilty to illegal contributions to Nixon's Committee for the Re-election of the President, CREEP. Prior to 1974, corporate executives flew to Washington with brown leather suitcases full of cash. After the dairy industry pledged $2 million to Nixon's re-election, he approved milk price increases. Secret slush funds financed dirty tricks and break-ins. Congress responded with the most comprehensive campaign finance legislation in American history. The 1974 Federal Election Campaign Act, FECA, amendments. The law imposed contribution limits, $1,000 per individual per election, expenditure limits, $1,000 for independent expenditures, $20 million presidential spending cap, comprehensive disclosure requirements, and created the Federal Election Commission to enforce these rules. Public financing of presidential elections was established through an income tax checkoff. Just one day after the law took effect, Senator James Buckley, joined by a bizarre coalition spanning Eugene McCarthy, the ACLU, the Libertarian Party, and the American Conservative Union, filed suit arguing the law violated the First Amendment. The Supreme Court heard arguments on November 10, 1975, and issued its ruling on January 30, 1976. The court's money equals speech doctrine transformed campaign finance into protected expression. The government argued that campaign finance restrictions merely regulate conduct, monetary transactions, not speech. The court emphatically rejected this position, holding that political spending is constitutionally indistinguishable from political speech itself. A restriction on the amount of money a person or group can spend on political communication during a campaign necessarily reduces the quantity of expression by restricting the number of issues discussed, the depth of their exploration, and the size of the audience reached. This is because virtually every means of communicating ideas in today's mass society requires the expenditure of money. The court distinguished campaign spending from cases like O'Brien, draft card burning, stating that the expenditure of money simply cannot be equated with such conduct as destruction of a draft card. Because money enables political communication, restricting campaign spending directly restricts the quantity of political speech. The First Amendment affords the broadest protection to such political expression to ensure the unfettered interchange of ideas. This doctrinal move transformed any spending limit into a speech restriction requiring the highest constitutional justification, a framework that would prove nearly impossible for reformers to satisfy. The contribution expenditure distinction created constitutional asymmetry. Buckley's most consequential and controversial holding treated contributions to candidates fundamentally differently from expenditures on political speech. This bifurcated analysis shaped all subsequent campaign finance law. Contributions received weaker protection because they involve only marginal restriction upon the contributor's ability to engage in free communication. A contribution serves as a general expression of support, but does not communicate the underlying basis for the support. The court found contributions were essentially speech by proxy. The actual communication comes from the candidate who spends the money, not the contributor. Given this attenuated speech interest, the government's interest in preventing corruption, and its appearance provided constitutionally sufficient justification for contribution limits. Expenditures received strict scrutiny because they represent substantial restraints on the quantity and diversity of political speech. When individuals or groups spend their own money on political communication, they are directly exercising First Amendment rights that the government cannot constrain based on vague anti-corruption concerns. This distinction meant that while Congress could limit how much someone gives to a candidate, $1,000 survived. It could not limit how much that same person spends independently advocating for that candidate, creating an immediate asymmetry that wealthy individuals could exploit. Independent expenditure protection became the dark money foundation. The court's most consequential holding for modern dark money was its ruling that independent expenditures receive full First Amendment protection and cannot constitutionally be limited. The $1,000 independent expenditure ceiling in FICA was struck down because it heavily burdens core First Amendment expression, while failing to serve any substantial governmental interest. The reasoning was straightforward but momentous. Independent expenditures pose no corruption risk because there is no direct exchange between spender and candidate. As the court wrote, the absence of prearrangement and coordination of an expenditure with the candidate or his agent not only undermines the value of the expenditure to the candidate, but also alleviates the danger that expenditures will be given as a quid pro quo for improper commitments from the candidate. This holding established that as long as spending is totally independent of the candidate and his campaign, made without prearrangement and coordination, it cannot create corruption and therefore cannot be restricted. The government's only legitimate interest in campaign finance regulation, the court held, was preventing quid pro quo corruption, explicit exchanges of money for political favors. The court also created the infamous magic words test in footnote 52, ruling that regulable express advocacy required explicit terms like vote for, elect, support, cast your ballot for, vote against, defeat, or reject. This created the issue advocacy loophole. Groups could influence elections without disclosure or limits simply by avoiding these specific phrases. What Buckley struck down versus what it preserved struck down as unconstitutional. Independent expenditure limits, $1,000 ceiling, candidate personal expenditure limits, $50,000 for president, less for Congress, overall campaign spending limits, $20 million for presidential general elections, upheld as constitutional. Individual contribution limits, $1,000 per candidate per election, PAC contribution limits, $5,000 per candidate, disclosure and record-keeping requirements, public financing of presidential elections, with voluntary spending limits as a condition. The court also struck down the FEC's original appointment structure as violating the Appointments Clause, requiring Congress to reconstitute the commission with presidential appointees. The line from Buckley to Citizens United shows doctrinal continuity. Not disruption. Citizens United extended Buckley's independent expenditure protection to corporations. It did not create something new. The doctrinal progression demonstrates how each major case built directly on Buckley's framework. McConnell v. FEC, 2003, upheld the McCain-Feingold Law's soft money ban and restrictions on electioneering communications by corporations. The 5-4 decision relied partly on Austin v. Michigan Chamber of Commerce, 1990, which had created an anti-distortion rationale allowing restrictions on corporate spending to prevent wealthy corporations from dominating political discourse. This was the one significant departure from Buckley's framework. FEC v. Wisconsin Right to Life, 2007, began eroding McConnell by ruling that BCRA's restrictions on corporate electioneering communications were unconstitutional as applied to ads that were not the functional equivalent of express advocacy. Chief Justice Roberts' plurality opinion explicitly invoked Buckley. Buckley itself compelled the conclusion that such tests fall short when it narrowed the statutory language there at issue to cover only advertising that used the magic words of express advocacy. Justice Scalia's concurrence noted the decision had effectively overruled McConnell. Citizens United v. FEC, 2010, explicitly built on Buckley's framework. Justice Kennedy's majority opinion quoted Buckley directly. Section 441B's prohibition on corporate independent expenditures is thus a ban on speech. as a restriction on the amount of money a person or group can spend on political communication during a campaign. That statute necessarily reduces the quantity of expression. Buckley v. Valeo, 424 U.S. 1, 1976. The court overruled Austin as an aberration from Buckley's framework, characterizing the anti-distortion rationale as incompatible with Buckley's First Amendment analysis. Under Buckley's actual framework, the identity of the speaker, individual or corporation, cannot justify restricting political speech. Citizens United was a return to Buckley, not a departure. SpeechNow.org v. FEC, 2010, completed the logical chain just 2 months after Citizens United. The D.C. Circuit unanimously struck down contribution limits to groups making only independent expenditures, creating super PACs. The reasoning combined Buckley and Citizens United in a syllogism. If unlimited independent expenditures cannot corrupt, Buckley, and this applies regardless of speaker identity, Citizens United, then unlimited contributions to groups making only independent expenditures also cannot corrupt. As the court put it, in light of the court's holding as a matter of law that independent expenditures do not corrupt or create the appearance of corruption, contributions to groups that make only independent expenditures also cannot corrupt. Scholars identify Buckley, not Citizens United, as the structural problem. Legal scholars increasingly argue that Citizens United was doctrinally inevitable given Buckley's framework, and that meaningful reform requires addressing the 1976 decision. Burt Newborn, NYU Law School, Brennan Center legal director, argues that Buckley erected for walls trapping democracy. The money equals speech equation, rejection of political equality as justifying regulation, differential treatment of direct versus indirect spending, and the assumption that independent spending poses no corruption risk. Together, these created perfect conditions for a black market in soft money, and made Buckley the principal architect of public, uniform abhorrence of the campaign finance system. Richard Hassan, UCLA Law School, documented in The 9 Lives of Buckley v. Valeo that only 3 of 8 participating justices agreed with Buckley's core holdings. It was a compromise opinion written by a committee. The contribution expenditure distinction has been sharply criticized since its inception, and both Citizens United and earlier cases relied upon Buckley, making it the doctrinal foundation that must be addressed. Richard Briffault, Columbia Law School, writes that Buckley produced a campaign finance law that Congress never enacted. The combination of unlimited spending funded by limited contributions led directly to our world of endless fundraising, PACs and other fundraising intermediaries, the explosion of independent spending, and the invention of a host of devices: soft money, issue advocacy, super PACs, dark money. Lawrence Lessig, Harvard Law School, developed the concept of dependence corruption. Candidates become dependent on wealthy donors in ways that distort democratic representation even without explicit quid pro quo exchanges. Buckley's narrow corruption definition excludes this structural distortion from constitutional consideration. The University of Akron Law Review documented that over 200 constitutional scholars signed a statement calling for reversal of Buckley's prohibition on spending limits. Attorneys general for 26 states and secretaries of state for 21 states went on record seeking to overturn the ruling. The coordination fiction enables de facto coordination through nominally independent groups. Buckley's framework depends on a critical assumption that independent expenditures are actually independent. Coordinated spending can be treated as contributions, but spending made without prearrangement and coordination receives full First Amendment protection. In practice, this coordination requirement has become, as the Campaign Legal Center documents, frequently an illusion. Super PACs are run by individuals who are personally close to a candidate or formerly associated with a campaign. Candidates appear as featured guests at Super PAC fundraisers. In 2024, Turning Point Action representatives stated they are officially an arm of the Trump campaign. The FEC has failed to enforce its coordination rules. The Campaign Legal Center reports the agency has never even fined a super PAC for working hand in glove with a candidate. In 2024, the FEC issued an opinion allowing campaigns to participate in joint fundraising committees with super PACs and share data for canvassing operations, further eroding any meaningful distinction between campaign and independent activity. This coordination loophole transforms Buckley's theoretical framework independent spending cannot corrupt because it lacks strategic value to candidates, into a legal fiction that enables exactly what Buckley claimed to prohibit. Buckley constructed the architecture that Citizens United furnished. The dark money system flows through constitutional channels that Buckley v. Valeo excavated in 1976. The equation of money with speech, the protection of independent expenditures from any limit, the narrow definition of corruption as explicit quid pro quo, the magic words test creating issue advocacy loopholes, and the coordination concept that separates nominally independent spending from candidates. Each of these doctrines predates Citizens United by decades. Citizens United expanded Buckley's independent expenditure protection to corporations and unions. Speech Now created super PACs by applying Buckley's corruption logic to contributions for independent expenditure groups. But the foundational architecture was built in 1976. As Representative Adam Schiff acknowledged when introducing a constitutional amendment, Citizens United was one of the most egregious enablers of special interest money, but it was only the latest in a long line of Supreme Court cases that opened the floodgates. Meaningful campaign finance reform must grapple with Buckley's doctrinal foundations. The Democracy for All Amendment, supported by over 40 Democratic senators, would address the fundamental flaws underlying the court's reasoning in that and an entire line of cases dating back to the 1976 Buckley v. Valeo decision. Until those foundations are addressed, whether through constitutional amendment, Supreme Court reconsideration, or creative legislative approaches that work within Buckley's constraints, the architecture of unlimited political spending that the 1976 court constructed will continue to channel dark money into American elections.